Good morning, all. Good mornings. Nice to hear. Okay, we'll start with this LLP. We started with LLP. We just touched upon what is LLP and all. So it's like a hybrid vehicle between your partnership and companies act. That's why we took that as the final chapter after your partnership and your company, so that you're aware of what how LLP is different. Okay, so it's usually called the hybrid vehicle between your partnership and your companies act. I'll start sharing my screen. Okay, so this Limited Liability Partnership Act 2008, I told you the way India is progressing, the economic growth, we need different kinds of organizations which will limit the disadvantages in each type of organization. So your partnership has a few disadvantages, your companies act has a few disadvantages. You're trying to make a hybrid organization, hybrid vehicle, which will kind of bring in the advantages in both the forms of organization. That's why this LLP was basically formed. Okay, and okay, so these are all introductions. What we will do is we'll look at the differences first. So we also touched upon a few initial definitions, right? So these are definitions which will be used in your later point in time for understanding the meaning of certain things. So what is a body corporate? Body corporate is a company as defined in section 3 of the Companies Act. So what is a body corporate? It is a company. Any body corporate can be a partner in your LLP. That's why this definition is given over here. Okay, so you should remember body corporate so that you know if they give a statement saying that a body corporate can be a partner in your LLP, then you should know what is a body corporate, right? That's why this definition is given over here. Body corporate is nothing but it includes companies, and it also includes a LLP registered under this act, which means that an LLP can be a partner. LLP can be a partner in your LLP. So that is possible. We'll look at the membership and all later. So basically, body corporate, what does it mean? It includes LLP registered under this act. It includes LLP incorporated outside India and a company incorporated outside India, which means that it is a foreign company. A foreign company can be a member, can be a partner in your LLP. The term used is partner, not member in LLP, limited liability partnership. So it is all partners over here. It is not members. It is partners. Okay. So partners, a foreign company can be a partner in your LLP, but it doesn't include a corporation sole. What is a corporation sole? It is like single man corporation kind of a thing. So basically, like these are special people like your CAG, Comptroller and Auditor General of India. CAG, you would have heard of that name. So he is called a corporation sole. So those are special people. They cannot be a body corporate, which who can be a partner in your LLP. And a cooperative society. You know what is a cooperative society, right? A group of members, group of people, association of people, and they are registered under this cooperative societies. So they cannot be a member in your LLP. So that is also excluded. And any other body corporate which the central government says that they cannot be part of your LLP. So those people are all excluded. And a few other definitions, basics, business. There are a few amendments in LLP, like business includes every trade, profession, service, and occupation. Now they have included certain things. So, in fact, for all the acts, wherever amendments are there, I will give you those amendments separately as a document itself so that it's easy for you. Basic, small differences, amendments, because law and even your RTPs, your revision test paper for every examination before your exams, institute will give the revision test papers. Usually, in the revision test papers, what they will give is they will give you questions from these amendments, so that they are trying to bridge the gap between your time when the textbook was printed, your module was printed, and the time in which you are giving the exam. And usually all the amendments which came before 6 months of your examination are applicable for your exam. Okay, so you could get questions in that. I'll give you whatever amendments are there which are there in law, and which could be part of your exam questions. Okay, that I'll give you separately. Now we'll just business is amended now. That's why I just wanted to tell you business. The definition is a little more exhaustive now. It includes a lot of other different things. So basically, business is your trade, profession, service, and occupation. And then designated partner, we have for performing your ROC filing, your operational issues. You have designated partners for doing that. We'll look at that in detail in section 7. Okay. Then entity is any body corporate, and then financial year we saw that you also in India financial year is April to 31st of March, the 1st of April to 31st of March. And if your LLP is it was not functioning for the whole year, then from the day on which your LLP started till the end of this 31st of March. Okay, so that will be your financial year for that particular year. And then foreign LLP, what does that mean? It is LLP formed, incorporated, or registered outside India, and it has a place of business in India. Similar to your foreign company, we saw that, right? It is similar to that. Everything, either you would have studied it in your partnership or in your Companies Act. It is just getting the nomenclature of LLP in this particular chapter. Everything else is almost something which you already know. Okay, then is your limited liability partnership. What is limited liability partnership? It is limited liability partnership as defined in this act. And what is this limited liability partnership agreement? Same as your partnership deed. In your LLP, you have limited LLP partnership, LLP agreements. Very similar to your partnership deed. It will have details of all the objective, your registered office, and then it will have details of your designated partners, their registered place, and all that will be provided in your partnership agreement. And internally, how the partnership, all your you remember partnership agreement, we could limit the extent to which the authority of partner can extend. For example, beyond 2 lakhs, you require consent from all the other partners. All that you can provide in your partnership agreement, LLP agreement. And partner, who is a partner? Any partner, any person who becomes a partner in the LLP accordance with the LLP agreement. So he is a partner. And your Indian Partnership Act 1932 doesn't apply to LLP. Companies Act, we see a lot of references to Companies Act. Okay, so that is wherever there are references, that is applicable. But your Indian Partnership Act, unless it is specifically provided, the provisions of the Indian Partnership Act shall not apply to LLP. Okay, so that is one thing. And we also saw that an individual or body corporate may be a partner in your LLP. So individual or body corporate. Individual is any individual, any human being, any normal person. That person can be a partner in your LLP. Or body corporate. Just now we saw the definition of body corporate. Body corporate includes your company. 2 companies can form a LLP, or 2 LLPs can form a LLP. So that is also part of your body corporate definition, right? Your body corporate includes LLP also. So 2 LLPs can actually come together and form another LLP, which was not possible in your partnership firm, because they're not separate legal entities. But LLP as such is a separate legal entity. So 2 LLPs can come together and form a third LLP. Okay, 2 LLPs can be partners in your LLP. That is possible. And your foreign company can be your partner in LLP. Everything is possible. So what is defined over here? Any individual or body corporate. So body corporate includes all those people, all those type of organizations or individuals who are included in that body corporate. So that is all part of your LLP. They can be partners in your LLP. But obviously, who cannot be a partner in LLP? The individual who is incapable of entering into contracts, which you've been seeing, who are all incompetent to contract. So they cannot be partners. Okay. Now we'll go to the differences between your LLP and partnership, LLP and companies, and come back to these sections so that you get little more idea of LLP. That's the end in your chapter, but that will give you more clarity initially. Okay, because you are aware of this, you'll enjoy this. Differences with other forms of organization, very important question again from your examination perspective. And The overall chapter weightage is around 6 to 8 marks in LLP. Overall chapter weightage 6 to 8. Very very simple chapter. Just 26 pages in your module, and direct questions if you're getting, then around 6 marks, 6 or 5 marks direct questions, and if you're getting practical questions like they could give you the number of members and ask you whether it is valid, or whether whether there is any as per the provisions of LLP, or what could be the number of members and all they could ask. So any type of questions are very very easy from LLP, direct, straightforward, 6 to 8 marks. I I'm hoping that you get all your 6 to 8 marks easily, which are given in your LLP, because very very straightforward, no thinking required at all. Just the provisions of the act, whatever is given in the provisions of the act, and apply it even for your practical questions. And theoretical questions is like halwa, real halwa. 6 marks if you're getting from LLP, then it is like real halwa, because it's like no application at all. Okay, so what are the differences between your LLP and partnership firm? 6 to 8 marks at least you are getting. Okay, LLP and partnership firm. What is the regulating act? Your LLP is Limited Liability Partnership Act 2008, and partnership is this. And then body corporate, whether LLP is a body corporate or not, it has a separate legal existence. So it is a body corporate. And partnership firm and partners and the firm are always the same. Okay, group of partners, they are together called the firm, and individually they're called partners. But end of day, your partnership firm and the partners are the same. So it is not a body corporate in your partnership firm, but this is a body corporate. And separate legal entity, obviously LLP has a separate legal entity. That's why that is the biggest advantage it is picking up from company form of organizations, or biggest drawback in your partnership firm. In fact, KPMG, it's called KPMG LLP. Okay, the partnership firm, many firms, they are converting into LLP to, in case of any liability of the LLP, it is the liability of the LLP alone. It is not the liability of the partners. Partnership, you know that it has unlimited liability of the partners. In case the firm is not able to meet the liabilities, then people will come and take the personal assets of the partners. Right. So that was one of the biggest drawbacks of your partnership firm, which is not the case of LLP. LLP has a separate legal entity, so it is separate from its members, okay, or its partners. And partnership firm, it has no separate legal entity. And how is it created? It is created by a legal process called registration under the LLP Act. So partnership, you know that, it is an agreement between the partners. It is voluntary association of people. They come together and do business. They may be registered. If they're not registered, they have their own set of disadvantages. But as such, the organization can still continue without registration. So it doesn't have a separate process and all. It is just created by an agreement between the partners. And registration of LLP is mandatory. Registration is mandatory. Just like your company, you have forms which need to be submitted to the registrar of companies. So I think I told you the other day itself, MCA, the Ministry of Corporate Affairs, your same registrar of companies manages your LLP also. Don't go don't invent something like registrar of LLP, all documents need to be submitted to registrar of LLP and all. So there is no registrar of LLP separately. It is the same registrar of companies. Okay, whatever documents need to be given, they all have to be given to your registrar of companies, ROC in short. Okay, and in partnership, your registration is voluntary, and there is a registrar for firms. Okay, that is separate. And only the registered partnership firm can sue the third parties. I hope you remember. Uh, Only if you are registered, then your right to sue others, or you can, in case of any issues, claim damages, all that. Only when you are registered, it will come. Okay, next is your perpetual succession. Obviously, because LLP is a separate legal entity, different from its partners, it has perpetual succession. Anything, come any partner, go any partner, nothing happens to your LLP. Same as your company. So death, insanity, retirement, or insolvency of the partners doesn't affect its existence. And members may join. It is not members, it is partners may join or leave, but LLP continues forever. And partnership firms, what happens in case, just imagine there are just two partners, and one partner dies or is incapable, then partnership firm automatically comes to an end. Right, so it doesn't have perpetual succession. Your partnership act will anybody can just give the notice and dissolve the firm. So that is not the case with your LLP. And name of your LLP, it has to have, this is mandatory, name of the LLP to contain the word limited liability partners as suffix. It either has to have this whole words or LLP in short. KPMG LLP is an example. You can see examples of LLP in India. We can do that. Okay, we'll just finish off this, and then we can also go through the MCA website and see what are the uh, how is LLP given. And then name, we just there is no as such, there is no guideline on the names given for partnership firms. Obviously, something which is undesirable, which is against unlawful things, you can, nobody is there to question you in your partnership firm, sole proprietorship and all, because it is not getting registered. I told you that day itself, there is a saloon in the vicinity. They can have a Royal Saloon as their name. It is possible because they're not going for registration. There is no authority to see if that this particular saloon is existing over here. So that is possible. But when you go for registration, when you take your documents to your legal authorities for registration, then legal authorities will check. Even for your companies, you saw that Royal or Crown, Prince, all that is not, you cannot have it unless you get special permission for that, right? So similarly, even in your LLP, you cannot have uh, all those names. Plus, it also has to have LLP as the suffix, limited liability partners or limited LLP as something which as part of their name. So it is mandatory that LLP is included. Similar to your companies, you should have limited or private limited, right? So it is same as that. And then liability of each partner, very, very important. Liability of each partner limited to the extent of agreed contribution. Agreed contribution, we call it as capital in your company, right? So in your LLP, you call it as contribution. So initial, whatever is your agreed contribution, the amount which you are bringing into the to the LLP. So that is the agreed contribution. Except in case of willful fraud. So you see that when limited liability becomes unlimited liability, it becomes unlimited whenever there is a fraudulent activity act which is done by the partner. So in that case, it will be an unlimited liability, but generally the liability is limited. And partners, liability of each partner is unlimited. It can be extended up to the personal assets of the partners. So in case the firm is not able to repay the debt, the third person has every right to take the personal assets of the partners. This is one of the most difficult part, or most worrying thing about having a partnership. In case something happens to the partners because of the mistake of some other partner, then you also become jointly liable, and the liability is also unlimited. Okay. And next is the next point, agency, mutual agency. What happens in case of a partnership? Every partner is a agent of all the other partners. He's a principal agent. We saw that, right? So that principal agency relationship exists in partnership. Here in LLP, each partner can bind the LLP, but not the other partners, right? So each partner can bind the LLP, but not the other partners. Here also, people are coming together. The partners are coming together, and they are performing acts. So whatever is their act, it binds the LLP as such, but not the partners. Which means that from the LLP's property, from LLPs, if there is any mistake or any act which is done by one of the partners, it is definitely binding the LLP. LLP's property is bound by that act, but not the other partners. And partnership firm, that each partner can bind the firm as well as other partners by his own acts. So each partner is an agent of the other partner, right? So that is the case of your partnership firms. And designated partners, there is this concept of designated partners. Why in LLP we have designated partners? Because in partnership, we know that the number of partners are limited, and it is more like a closed knit organization. But there are a lot of, but in case of LLP there is no limit on the number of partners. So what will happen is there'll be so many partners, and there has to be some legal formalities which need to be done, right? Your filing of returns, your annual your ROC related matters, all that needs to be dealt with. Somebody has to be, somebody has to be held responsible in case they are not perform that act, right? So they are the designated partners in case of your LLP. There has to be at least two designated partners. There has to be at least two designated partners in your LLP, and at least one of them shall be resident in India. Okay, so which means that at least two partners. In case of LLP, minimum number of partners is two. So those two partners, in case there are no other partners, then obviously they both become the designated partners. Okay, so but there has to be two designated partners who will, basically it's like, it doesn't mean only those two designated partners can only do all the acts of the firm. It is not that way. But all the operational issues, like filing your tax returns, your filing of annual returns, all those operational issues, legal compliance, have to be taken care of by these designated partners. If something goes wrong, if the forms are not being filled on time, then these designated partners will be jailed. All that is applicable for this designated partners. So if at all somebody has to question in LLP, they can go and question these two designated partners for all these compliance related issues. But we know that any partner can enter into contracts, all that is possible. But these designated partners are basically for compliance related issues. Okay, otherwise in the agreement they can actually give active partners, and designated partners could be different in your partnership agreement. That is all applicable for your LLP also, right? So your LLP agreement can have names of people who can act for the firm. All that is possible. But designated partners, there will be two designated partners, and at least one of them has to be a resident in India. They will manage all the compliance related issues. There are number of compliances for LLP also. Okay, and there is no concept of this designated partners in your partnership firm. And common seal, it may have its common seal as its official signatures. It may have, similar to your company. So in company also we saw that, right? This common seal, the concept itself is losing its charm, because you have a director and secretary can sign. There are other options which are available. So common seal doesn't have that much of significance these days. So it may have its common seal. In case that is given in your agreement, saying that any agreement for binding the LLP, it should have common seal in your LLP agreement, then obviously you will have your common seal. And there is no concept at all in partnership for your common seal. Okay, next, legal compliances, only designated partners. So here, if you see, only designated partners are responsible for all the compliances and penalties under this act. Very, very important. So all your legal compliances, legal taxation related compliances, only designated partners are responsible. They have to perform all the acts, all the legal formalities with respect to your LLP. Okay, and next is your all partners are responsible for the compliances and penalties. See, partnership is a closed knit organization, right? A maximum there can be 50. So it your anybody can be held. It is easy to trace, right? So all partners are responsible for the compliances. So everyone is equally responsible for the penalties and fines which are given by law. Okay, next is your annual filing of documents. So similar to your company, see, LLP also, it is not like, we saw that in companies it is very, very strict. We have lot of compliances and all. So LLP is also a separate legal entity. So LLP also has filing of documents, annual filing of documents, which are mandatory. But obviously extent of, the number of forms which need to be filed, or the extent to which it is so strict, it is not the same as your company. But definitely your LLP also has certain mandatory filing of documents, annual filing of documents, annual returns, your insolvency statement, all that needs to be filed by the LLP also. It is required because it's a separate legal entity. People should know what is happening in your company, right? There are unlimited partners. So it is like, people should know what is happening in your LLP. Therefore, annual statement of accounts, statement of solvency, annual return with the registration of LLP, all these are mandatory documents which need to be filed with the registrar of companies. ROC manages this also, right? So these need to be filed. Partnership firm is not required to file any annual document with the registrar of firms. So partnership firm, that kind of submission of annual documents, those are not there. And foreign partnership, foreign nationals can become a partner in LLP. So we saw that in the body corporate definition, it also includes foreign nationals or foreign corporates. So foreign nationals can become a partner in LLP. Foreign nationals cannot become a partner in a partnership firm. So it has to be foreign. It can be a body corporate, but it doesn't include, like, companies can form partnership firms, but your foreign nationals cannot become a partner in your partnership firm. And minor as a partner, do you remember? Minor can be admitted to the benefits of the partnership with the prior consent of the existing partners. We saw all extensively what are the sections which are applicable to minor, right? So all that is possible in case of a partnership firm, but minor cannot be admitted to the benefits of LLP. So it is similar to your company only. Company, you remember, in the initial subscription, when the company is allotting shares, that time a minor cannot enter into a contract. Do you remember that a minor cannot enter into a contract when the company is allotting shares? Later on, when the minor has inherited shares from his legal inherited shares, or somebody has transferred it for his benefit, then it is possible. Similarly, in your LLP also, minor cannot be as such admitted to the benefits of LLP. Even in case of company, it is the same thing. Minor as such cannot be a member, but due to inheritance and all, he can hold shares for the benefits of the minor. So that is possible. But in partnership, what can happen? Minor can be admitted to the benefits of the partnership with the prior consent of the existing partner. So when somebody has to be taken admitted as a partner in a partnership firm who's a minor, then all the other partners have to give their consent, right? So those are the differences between your partnership firm and your LLP. So there are 15 points which are given in the book. Obviously, when you are getting this question in your examination for 5 or 6 marks, you are expected to give only 5 or 6 points. Okay, whatever is the 1.1 mark. That's it. That's the rule. And 1 point you need not give simple. uh, it has to have important points like your separate legal entity, your body corporate, your registration, and your perpetual succession. These are important points, right? So you common seal and all, it is not that very important. And legal compliance is only designated partners, all that doesn't look that very important. So primary points have to be there: your body corporate, separate legal entity, and your perpetual succession, and even your regulating act. All that is important. Limited liability of your partners, all that looks very important. So try to include all the important points so that examiner is happy. There is no rule as such, but to make examiner happy and he giving you that entire 5 or 6 marks, give all the important points first whenever you are having this kind of a question. Because even in last test, I saw that when question was asked on when questions are asked, you're trying to give points which are not that very important. I want the crux of it. So as an examiner, as a person who's correcting the paper, I'll be happy if you give the most important point, differentiating point between these two companies. Okay, so that's why I'm giving you this as a point explicitly. Generally, please give all the important points. Okay, next is your LLP and company. What are the differences? Again, what is the regulating act over here? Your LLP Act 2008 and your Companies Act 2013. They are the regulating acts, and members are partners. The persons who contribute to LLP are known as partners of the LLP. Okay, they're all partners only. It's a partnership. It's a limited liability partnership. Okay. So the persons who contribute to LLP are known as partners of the LLP. The persons who invest money in the shares are the members of the company. An internal governance structure, again, it is given by the agreement between the partners. The internal government structure is in a company is regulated by statute. So the number of directors, the number of managing director, all that is the number of board meetings which should happen, the number of everything is given in your company's act itself. Okay. And your name of the LLP to contain the word limited liability partnership or LLP as suffix. So it should have these words, excuse me. And company, name of the public company to contain the word limited, and private company, it should have the words as private limited as its suffix. And number of members or partners, minimum two members, minimum two partners. It is actually LLP, minimum two partners, right? And maximum, there is no limit as such on the maximum numbers. So but these minimum two members, you should have two designated partners, and one of the designated partners has to be a resident in India who stayed in India for more than 182 days in the previous financial year. You'll see that. So this minimum two members, just remember that two members, two partners have to be there, and there has to be two designated partners, and in those two designated partners, at least one has to be a partner who is a resident in India. So those are all the clauses which are for your LLP. And your private company, you know all that now. Minimum two members, maximum 200. And then public company, minimum 7 and no limit on the maximum. And yeah, members can be organizations, trust, another business form, or individuals. So liability of members or partners. Liability of partners is limited to the extent of agreed contribution over here. Here, liability is limited to the amount unpaid on the shares held by them. So it is talking about limited liability shares, uh, limited liability company. It is not about unlimited company. Unlimited company, obviously, the members' liability is unlimited. But in case of limited liability, either by guarantee or by shares, it is limited to a certain amount, right? Here it is the agreed contribution in LLB. And management, who manages the business of the company, managed by the partners. Okay, so basically, business of the company is being managed by the partners. It is not the designated partners. Designated partners are for your legal compliances, for your registration, for dealing with your ROC, your IT, all those income tax, all that only is your designated partners. Rest, the management, everything that is based on the agreement, the partnership agreement, the LLP agreement, which gives you details on how the business should be managed. Okay. And the affairs of the company are managed by your BOD, Board of Directors, elected by the shareholders. And minimum number of designated partners, minimum two designated partners have to be there. And private company, there are at least two directors, and public company, three directors. So they are all part of your people who manage. Okay, so now I think you have a fair idea of what LLP is and what a company is. So how it is different from your partnership firms and your companies. So now we'll go back to, isn't it? It is kind of giving you the advantages of both the forms of organization. Do you think so? I think I gave you asked you one question the other day also. Somebody is coming and asking you, they have to start a hotel business or some business. And then as a consultant, what will you think of? You will think how many people are there. You will have to assess all those whenever you're giving your consultation. You have to assess what is their turnover, what is their expected turnover going to be, and how many partners are there, and what is the relationship between the partners. So if it looks as if they're all not very close people, or just for the sake of business they're coming together, it is definitely better that your liability is limited, because you cannot bind the other partners in case of LLP. All that you will take into consideration. Okay, now let's go back to your LLP, starting from your definitions. We saw that body corporate and all the definitions. Now next thing will be before incorporation. Let's look at the minimum number of partners. So what is the minimum number of partners? Section 6, every LLP shall have at least two partners. So minimum two, at least two people have to come, right? So at least two partners. If at any time the number of partners is reduced below two, very, very important provision. So anytime the number of partners is reduced below two and the LLP carries on business for more than 6 months, so then the person who was the only partner at that point in time, he will be personally liable, which means that unlimited liability comes into picture for all the obligations of the LLP incurred during that period. For example, if if your LLP, there were two partners, and from 1st of January, 31st of December 2021, one partner is also gone. So two partners, 31st of December 21, from that day onwards, the other partner is also left. Now, what is the law saying? The law is saying from 1st of January 2022 till 30th of June 2022, whatever liabilities are being incurred or whatever are the obligations of the LLP, that will be the obligation of the LLP. Okay, which means that the liability of the partners is only limited to their contribution. So there's only one partner. So A and B were there over here. Now only A is there, B is left. So still from 1st of January till 30th of June, whatever are the obligations, that will be the obligations of LLP as a whole, not A's. But after 30th of June, whatever contracts are being entered into from 1st of July 2022, any obligation is being entered into by A alone. If there is no other partner who is joining in this firm, then it will be the obligations of A alone. It will not be the firm's liability, LLP's liability. It is the liability of this person shall be liable personally for the obligations of the LLP incurred during that period. So if he is doing that business, then it is not right. He has to have one more person. Or if he is still doing, then it will be the responsibility of that person. Next, section 7, designated partners. Very, very important. Every LLP shall have at least two designated partners who are individuals. Why are they stressing that, there have to be two individuals? Because they have to look after the compliance related issues. They have to liaise with your ROC, liaise with your taxation authorities, which means that they have to be individuals who are actually managing this. So they have to be individuals. Two partners have to be individuals, and at least one of them shall be a resident in India. So out of these two people, at least one should be a resident in India. We are stressing that they have to be individuals. And then what is the point if those two people, they are not in India, you're not able to catch hold of them, right? Basically, if you're not able to catch hold of them, then what is the point in having individuals? That's why law specifically says that at least one of them shall be a resident in India. Very, very important from your practical questions perspective. Okay, you have enough questions which are asked in this particular topic. And if in LLP, all the partners are bodies corporate, or in which one or more partners are individuals and body corporate, at least two individuals who are partners of such LLP or nominees of body corporate shall act as designated partners. So what are they trying to say? They're trying to say that there have to be two individuals in a LLP, right? And we also saw that two companies can, or two LLPs as such, they can also be a partners. They can be a partner in this LLP, right? So in that case, they have to have nominees. So at least two individuals who are partners of LLP or nominees of such body corporates shall act as designated partners. So at any point in time, we need two people, individuals who have to be designated partners. So in case the partnership firm, in case the LLP has only bodies corporate as partner, body corporates as partners, then they have to appoint nominees, two individuals who are nominees of those body corporate, who will be the designated partners. Okay, so example also given over here. LLP, this LLP has three partners, and this will not be consideration because the requirement for LLP is to have two individual members as partners. So accordingly, must consist of at least five partners. So basically, either you should have, or you have two nominees, two people appointed as nominees, and then tell that they'll be nominees, and then go for registration. Okay. But without nominees, just having two people, two body corporates as your LLP's partners is not possible. And resident in India, for the purpose of this section, resident in India means a person who has stayed in India for not less than 182 days, which means that 182 days or more during the immediately preceding 1 year. So out of these two designated partners, at least one person has to be a resident in India. Okay. What is a resident? How is it defined? At least 182 days they have to have stayed in India in the immediately preceding financial year. So then they'll be called as the, sorry, not financial year, immediately preceding 1 year. It is always, whenever financial year is given, it is financial year. Otherwise, it is year, immediately preceding year. So that then that person will be considered as a designated partner. It is valid. So here again the example, LLP and having five partners, Mr. A, B, C, D, and E. At least two should be named as designated partners, out of which one should be a resident. Hence, if Mr. A and B are designated, so what are they saying? It is given over here explicitly that A and B are non-residents. Okay. So which means that C, D, and E say there has to be at least one person who's a designated partner. One of the designated partners should be there out of Miss C, D, and E. So non-resident can be called as a designated partner. There is no issue, but there has to be one more person who is a resident and is a designated partner. Okay. I hope it's clear. Okay. Any doubts on designated partner? Very important topic. Any doubts?
No, ma'am.
Okay. Okay. Next, we'll go on to okay characteristics of LLP. Before going to this, we'll see how LLP is registered. Okay, we'll because textbook the way this chapter is given, it's like it's very vague. We'll look at it step by step. Now, next is your registration. Similar to your incorporation of your company, you have this registration of incorporation of LLP. So let's also look at MCA website for this. Those are all not given in your what is given in your textbook is kind of very vague and outdated. But what happens is, first of all, for incorporation of your LLP, what is required is you have to, so this is the final crux, steps to incorporate LLP. First is your name reservation. It is called run form. So we'll look into your MCA. MCA, even in your sleep, you should be able to tell LLP, you don't have any separate registrar. It is again your ROC, registrar of companies. So all documents need to be filed. Don't be over enthusiastic and write registrar of LLP and all. It is the same registrar of companies. And if you look at the services, LLP filing. Okay, you see that, right? LLP filing. You have this run LLP, RUN LLP. So what is this run LLP? Reserve unique name. So that is the first step for your LLP. Run LLP, reserve unique name. So what happens is, name reservation is the first step for your incorporation. You will go and reserve a name. That is the run form, RUN, reserve unique name. That's not given over here. This E form 1 and all is outdated, really outdated. So the latest is, it is called run LLP. If you see over here, it starts from form 3. You're able to view the screen, right? You're viewing the screen, right?
Yes, ma'am.
So it talks about form 3, form 4. It doesn't talk about form 1 and 2 because it's the new terminologies which are given are reserve unique name. It is not this E form 1 anymore. It is run LLP, reserve unique name. You can give that in your exam answers also. It's not a problem at all because that is what is happening right now. So applicant has to file this reserve unique name form for ascertaining the availability and reservation of the name. Say, for example, you want to have some name and you have to first of all check if that name is available, right? So that and then give that form to your register that run with your registrar of companies. Let's see if we can. Okay, it is asking for login. I used to have login earlier, now I don't have. Okay, so let's see if, or you can just Google it after going home and see how a run LLP looks like. It will just ask for basic details of what names you want to get. That's anyway not part of your syllabus, just for your understanding and enthusiasm. You can go through that. So first of all, you have to reserve the name using this run form. And then what you have to do is second form. This is not E form 2 again. It is called the Philip now, the incorporation form, the form which you file to the registrar for getting incorporation, similar to your Spice Plus. You remember Spic or Spice? It's called Spice Plus. It is called Philip form over here in LLP. And what does that stand for? Your Philip form, Philip incorporation of LLP. What is Philip? Form for incorporation of limited liability partnership. Form for incorporation of your limited liability partnership. So Philip form, if you take that and you download that, and then you I will see if that is again that is asking for your this one registration, your login credentials. So leave that. But that's the second form which you need to, which is the formality for getting incorporation. First is your run form, your reserve unique name form. You will send it to you will file it with the registrar, and ensure that your name is not similar to any other LLP or company, or it is not unlawful or undesirable, all that. So it should be a proper name, and it should also have LLP as suffix, LLP or limited liability partnership as suffix. So you will file that form. After that form, what will you do? You'll file this Philip. It is not E form 2, it is called Philip now. Philip is form for incorporation of your limited liability partnership. That is your Philip form. That you will file with the registrar of companies. And then after they give the incorporation document, I hope that incorporation document is available in Google itself, similar to your company's incorporation. So in company, you got the SIN, right? Corporate identity number. Similarly, in your LLP incorporation certificate. So you'll have LLPIN, limited liability partnership identity number, similar to your SIN, same as your SIN. So your Ministry of Corporate Affairs, your MCA gives us LLP identification number, certificate of incorporation. Once you submit this run, once you give this run and fill up, the next point is they are going to give you the Ministry of MCA is going to give you LLPIN, which is LLP identification number. So they are giving you this similar to your corporate identity number SIN. That will be available in your certificate of incorporation, right? In your LLP, it is LLPIN. You'll have that. Okay. So that is the final step. After they give this they give you this incorporation certificate from MCA, your responsibility, so the LLP's responsibility is to execute this LLP agreement, which is as per section 23 of this act. What do they do? I told you, right? LLP, similar to your partnership deed, all your details about this particular LLP, you will have it in this LLP agreement, and that needs to be filed with the registrar in E Form 3 within 30 days of incorporation of LLP. So they will give you this incorporation certificate. After they give you this incorporation certificate, what do you have to do? You have to file this E Form 3 within 30 days with your LLP agreement. Okay, so that is how the steps are for your incorporation. So I think if you go to this, see Form 3. So after run and fill up, it comes, what comes next is your form 3, information for LLP agreement and changes. So you will file this particular LLP agreement, and in case in future you are making changes to your LLP agreement, your partners are leaving or your designated partners are being changed, all that you will give in this form 3. Okay, these are all procedural, but it is better you are aware of it. This is simply the process for your incorporation of LLP. And let's see what is given in your textbook in detail with respect to name and all. Incorporation of LLP. The most important is the incorporation document. For LLP to be incorporated, two or more persons, they have to give. So all those will be contents in your form. First is not your incorporation document. First is your reserve unique name, that form. So that, name. reservation of name. Section 15. Every limited liability partnership shall have the words limited liability or LLP as part of its last name. And no LLP shall be registered by a name which, in the opinion of the central government, is undesirable. Undesirable, as in you are giving some, bad names. Terrorist is included in your name. So then government is going to say no. And identical or too nearly resembles that of any other partnership or LLP or body corporate or a registered trademark or a trademark which is the subject matter of an application for the registration. So, uh, usually they will use different names in your trademark also. For example, your Paytm is what you colloquially call it, right? But its actual name is different. If you look at Paytm, you can Google it. I think it is 197 or something like that. The actual name of the company is 197. It is not Paytm. But do we even know that 197 and all? We only know this Paytm, right? So in case you are going and filing Paytm again because that Paytm name is not being used, then government may not give you, because that is something which is being used already by another company, though their actual name is not Paytm, which is registered. So those names government may say no, saying that it resembles another company. Even your Ola, the name is very different. The actual name of the company is very different. It's not Ola. Let's just search for that. I'm also curious. Ola Wikipedia. Ah, so Annie Technologies is the uh, company. Annie, that is the name, and then this is the colloquial name which is given. Okay, so similar. So basically, I want to tell you that if some name is being used by another company, you cannot use it. And reservation of name, section 16, a person may apply in such form, which is nothing but your run LLP. So you have to pay fees and then get a proposed name for your LLP, and the name to which LLP proposes to change its name. So upon receipt of an application and on payment of the prescribed fee, the registrar, he may actually reserve the name, or he may reject it also, right? He may reject it if it is not desirable or anything of that sort. Then he can actually reject that name, reserve okay, so he can reject it also, and then reserve the name for a period of 3 months from the date of intimation by the registrar. So after reserving the name, you cannot sit simply. Within 3 months you have to file the incorporation document, this Philip document. So you reserve the name, and then after 3 months also you don't do anything, then the name is not going to be reserved for you. It is going to go away. Even your names of movies and all, for example, the a director thinks of some name, and which is which he thinks is very very charming, and he can actually reserve that name for, so that nobody else can have that title as the name of their movie. So he can reserve it even 5 years or 6 years before he actually takes the movie. All that is possible. And in case of this LLP, it is 3 months. For 3 months the registrar is going to have that name. Okay, so that is reservation of name. After that, what are you going to do? You are going to file this registration document. And what are the details which you're going to give in the reservation incorporation document? So you'll give all the incorporation document shall be in a form which is prescribed, which is Philip, and state the name of the LLP and state the proposed business, your address, your all that. State the name and address of each persons who are partners, and then your designated partners, all other information which is useful, which is relevant for your incorporation. You will give all that, and then that has to be there, a statement which needs to be ratified by your advocate or company secretary or a chartered accountant or a cost accountant who is engaged in the formation of the LLP, similar to your company. So there has to be somebody. This statement also, declaration by such a person, that is required while you're submitting the incorporation document, and by anyone who has subscribed his name to the incorporation document, that all the requirements of this act and the rules made thereunder have been complied with. The declaration stating that we have complied to the rules. Okay, there has to be somebody who declares. Okay, so that is how you will file the incorporation document. And again, if a person makes a statement which he knows to be false or doesn't believe to be true, then what is the punishment? With imprisonment for a term which may extend to 2 years, and with a fine, which is this is given 10,000 and which may extend to 5 lakhs. So this is when you are submitting the incorporation document. If you are providing something which is not right, knowingly, then this is the punishment you might get. Okay, next is incorporation by registration. When the requirements, these requirements are or given to the registrar, then within a period of 14 days, register the incorporation document and give a certificate that the LLP is incorporated by the name specified. That is the incorporation document which we were just seeing. The certificate of incorporation that will be issued by the registrar, and within 30 days of the certificate of incorporation, what you need to do, you need to give the LLP agreement. You need to file that in form 3 with the registrar of companies. Okay, all these are procedural, yeah, but you should know, because I told you at least 6 to 8 marks from LLP, and very easy chapter. And registered office of LLP and changes anything similar to your company, you have to intimate the ROC about any changes. Every LLP shall have a registered office. So, and it will also give you, it should also give the place wherein all the communication needs to be sent. And LLP may change the place of its registered office and file the notice of such change with the registrar. So it has to file it with ROC. If the LLP contravenes any provisions of this section, the LLP and its every partner shall be punishable with a fine which shall not be less than 2,000 and which may extend to 25,000. So registration related issues, it is not just designated partner. You can probably, these could be small things, but it could be asked in examination. They have not asked till now, but they could ask you, right? So in case registered office change is not being intimated, and who is going to be punishable? The LLP and its every partner shall be punishable with a fine which shall not be less than 2,000, but which may extend to 25,000. So 2,000 to 25,000 could be the fine if you are not following the formalities. And then next important thing, effect of registration. So what happens when you register? So after the registration, it obtains that status of legal entity. So on registration, LLP shall by its name be capable of. So from that day onwards, it is getting its birth. So it can sue, and it can also be sued by other entities, and that all is going to be in the LLP's name and not in the name of the partners. Okay, so what can it do? It gets a legal status. So it can acquire, own, hold, and develop or dispose properties. It can enter into contracts. It can do all other acts as any body corporate may lawfully do and suffer. And it can have a common seal if it decides to have one. If it wants to have a common seal, then it can have a common seal. So this is all. This is all about your incorporation and what happens after incorporation and all that. So, okay, that completes your incorporation. Clear everything? Incorporation?
Yes, ma'am.
Okay. Next is your partners and their relations. We saw that in the differences already, right? This mutual agency, it is applicable up to some extent. So what does it mean? The acts of the partners are binding the LLP, but not the partners, not the other partners, which means LLP is liable to the extent if a partner has acted within his authority, then it is binding on the LLP, but not the other partners. That is the only difference between a partnership firm and LLP. And in case of members, in case of companies, it is altogether like, one member cannot bind the act of other members. It's like, shareholders, one shareholder is a member, right? One member, whatever he does, it is not binding on the company or the other members. But in case of your LLP, corporation, the persons who subscribe their names shall be its partners. All that is okay. So, what is the relationship of partners? The mutual rights and duties of the partners in LLP and the mutual shall be governed by the LLP agreement. So here also your LLP agreement comes into picture again. So your LLP agreement supersedes anything else. So LLP agreement between the partners or between the LLP and its partners, the LLP agreement and changes shall be filed with the registrar. New partner is coming, partner's name changes, anything, all that, any changes in agreement, that shall be filed with the registrar. So, okay, or the same thing. The absence of agreement, the mutual rights and duties of the partners shall be determined by the provisions relating to that matter as set out in the first schedule. There is a first schedule to this LLP Act, which will, so in the absence of any agreement, so that will be part of your LLP Act. So LLP Act, if you look at that, so this is the Bear Act. So it has, okay, it is not in, it is scanned. Okay, so then you'll not be able to scroll. So it has first schedule, second schedule, and all that. So you, in case the agreement doesn't have anything, then your mutual rights and duties, that will be basis the first schedule, whatever is given. Okay, and then cessation of partnership interest. So obviously, whenever like a partner can enter into an LLP, a partner can also, stop being a partner in this LLP. It is possible, right? So in that case, what happens? A person who, so 30 days notice has to be given by giving a notice in writing of not less than 30 days to the other partners of his intention to resign as a partner. So basically, whenever a partner wants to go out of the firm, go out of this LLP, what does he have to do? He has to give a notice to the other partners for, not less than 30 days, which means that at least 30 days notice has to be given to the other partners of his intention to resign as a partner. And a partner can also, a person shall cease to be a partner on his death or dissolution of the LLP, or if he is declared to be of unsound mind, and if he is applied to be adjudged as an insolvent person. So in all these cases, a partner ceases to be a partner in the LLP giving a 30-day notice, or if he is incapable due to these reasons, he can be, actually he can come out of, he can cease to be a partner in the firm. So when a person has ceased to be a partner of LLP, so will this is important. So when a person is, not a partner in LLP, what happens? So for example, there's a retiring partner. So there's a partner who is retiring. Now we know that registrar should be given 30 days notice, or he has to give it to the other partners, and again even to the registrar it is 30 days notice. Within 30 days they have to intimate to the registrar also. Now this retiring partner, in case he is retired now, so in that case, if a third party is entering into a contract with this retiring partner, then what is the liability? In case the third party is aware, third party is aware. So just example, for example, this partner A is leaving the partnership firm, and he is entering into into a contract with somebody called X. So this X is a third party, and A is entering into a contract with X. Okay, and this third party, two situations. One situation is this third party is aware. He knows that A is no longer the partner in the firm. He knows that this party is no longer the firm. Then this LLP is also not liable. Okay, this LLP is also, this partner cannot bind the LLP also. The person has noticed that the former person has ceased to be a partner of the LLP. So what does that mean? The former partner has to be regarded as still being a partner of the LLP unless the person has noticed that the former partner has ceased to be a partner. So in case the third party is aware, so in that case, there can be no liability. This is a void. This is void, and this person doesn't have, it's void as in this person cannot hold the LLP or this partner responsible for any acts which is, which he is aware that this person is not the partner, and he's not doing in partner's capacity. If he's aware and if he's still entering into the contract, then he cannot hold the LLP responsible. Okay, so that is if the third party is aware. If the third party is not aware, so this X is not aware that this A is no longer the partner, then in that case, what will happen? Have you informed the registrar? Is ROC aware? So this is no. In case no, third party aware, here it is yes. And in case it is no, is the ROC aware? Which means that have you informed the ROC that your this person is no longer a partner? Is ROC aware of this fact? If ROC is aware, okay, if ROC is aware, then the liability comes to an end over there. So this person cannot again hold the LLP responsible because ROC is kept informed that this person is no longer a partner. So if even though the third party is not aware individually, it was his responsibility to check with ROC that this A is still the partner of the firm, right? So if he has not done, then it is not my problem. So in that case also your LLP is not liable. But just imagine this ROC is not aware. ROC is not aware. If ROC is not aware, which means that the partners have not informed the ROC that A is no longer a partner, then the firm's liability continues. LLP's liability continues. You're getting this point? So, with that note, just read this point. So, where a person has ceased to be a partner of LLP, okay, so he's called the former partner. Where a person has ceased to be a partner of LLP, the former partner is to be regarded as still being a partner of the LLP, which means that LLP is also, jointly liable. They're still being a partner of the LLP unless the person has noticed that the former partner has ceased to be a partner of the LLP. So he will be considered as a partner of the LLP unless he has given notice. The third person who is entering into this contract, he is aware that this person is no longer a partner of the LLP. If he is aware or notice that the former partner has ceased to be a partner of the LLP, has been delivered to the registrar. So basically, if you have informed the registrar, it is like your constructive notice, right? You cannot go and inform each and every person on this earth that I'm not a partner anymore. So once you inform the registrar of companies that I am not the partner, that this person is not the partner anymore, then in that case, your it is like a constructive notice, and from that day onwards, your LLP is not liable for the acts of this partner who has left the firm. Clear on this? So where a person has ceased to be a partner of LLP, the former partner is to be regarded as still being a partner. He will be considered as a partner only when, but exceptions are when the person has noticed that the former partner has ceased to be a partner. So third party, when he is entering into the contract, he is aware that that this person is no longer a partner, but he's still entering into contract. Then you cannot bind the LLP liable. Okay, so that is not possible. And also, or it can be the giving a notice to the registrar. If you have informed the ROC that I'm no longer a partner in this LLP, then also your the liability of LLP comes to an end with respect to all those contracts. Okay, and even you will not be considered as a partner anymore. So even your up to your capital contribution, you are liable to the LLP, right? So that is also not applicable. Basically, you are not regarded as a partner anymore in that particular LLP. If you either inform the ROC, or even if you're not informed ROC, if the third person is aware that you are not the partner anymore. Clear? Clear? Just
Yes, ma'am.
understand it. Yeah, just understand it, and then when you revise it once after you go home and read, you will be able to appreciate it. So the same thing, like your retiring partner, you remember retiring partner, the same logic. Retiring partner here, but that is not explicitly given over here. What will happen in case that's given in your Bear Act? What happens in case this person has informed the LLP? This person A has informed the LLP, but LLP has actually not posted it to ROC. So that is also possible, right? Now, this person A, what is happening? He is the retiring partner. He has very well informed your other partners. He has informed the LLP that he is going to retire, and he is thinking that, it all the formalities are done from his end. But what is happening? The designated partners who actually deal with ROC, they haven't informed the ROC. Then in that case, what happens? It is not given over here explicitly, but what happens is, so it is the, if the this particular part, again this person's liability is going to continue till the registrar is informed. But poor thing, this A has actually informed the other partners, right? So it is not his mistake whatsoever. So it is the mistake of the designated partners. But law doesn't see it that way. What does law do? Law is seeing whether the ROC is being informed or not. So what will happen is, uh, law is giving you an option to this retiring partner to directly go and inform ROC itself. You can directly go and inform ROC that I'm no longer the partner in this firm, and I have given a notice to this particular firm, to this LLP karke. He can directly go and inform ROC. And ROC in turn, what will they do? They will actually check with this LLP, and they'll give a period of 15 days for the LLP to get back. They'll give a period of 15 days to the LLP to get back on whether this A's contention that he's no longer a partner is right or not. If within 15 days they don't get any feedback from this particular LLP, then silence is assumed that A's statement, whatever he said, that is correct. So ROC will remove that person's name from their particular register, the registration document. They will remove it directly because A has voluntarily gone and informed ROC that he is not a partner in the firm anymore. So what is ROC going to do? They're going to cross check that with your LLP firm and check whatever he's saying is right or not. If LLP says right, yeah, he is no longer a partner, then it is well and good. If LLP doesn't give any feedback on that, then also it is assumed that within 15 days this person's name will be removed. Okay, so that is how it functions. Okay, so it is a basically it is a responsibility. ROC has to be informed that this person is not a partner anymore for him to be discharged of any liabilities which are there in LLP going forward. So next is your, the cessation of partners from LLP doesn't itself discharge the partner from any obligation to LLP or to other persons which is incurred while being a partner. So whatever was incurred while he was still a partner was his responsibility only. Obviously, through the LLP agreement, they can say that from this day onwards, whatever we will manage all the liabilities, and this person is relieved from all the liabilities is something which can be given in the LLP agreement. A partner of LLP ceases to be a partner unless otherwise provided in the LLP agreement. The former partner or person entitled to his share, okay, shall be entitled to receive from the LLP. What are you entitled to receive from the LLP? Once you, come out of the LLP, an amount equal to the capital contribution of the former partner. So whatever was your capital contribution, that you can have, and even your accumulated profits after deduction of your accumulated losses. So that is your on coming out of the partnership firm LLP, you will get these. Okay, so that is about you coming out, a partner coming out of this LLP. A former partner or a person entitled to his share, okay, shall not have any right to interfere in the management of the LLP. So once you come out of the firm, you cannot get involved in your management of the LLP. Okay, registration of changes in partners. So it is given over here in detail. So every partner shall inform the LLP of any change in his name or address within a period of 15 days of such change. Every partner shall inform the LLP. A LLP, where a person becomes or ceases to be a partner, file a notice with the registrar within 30 days where he becomes or ceases to be a partner. Whenever there is an admission or a retirement of a partner, you have to inform the ROC within 30 days. Okay, that is your responsibility. And when each where there is any change in the name or address of a partner, even your name or address of the partner, all that can change, right? Your name, same partner, he can have a different name for the sake of numerology or whatever. You can have you can make changes to your name and all, right? So if at all there is any change, then that also again has to be informed to the registrar of companies. That also is applicable for your directors also. Your directors disclosures and all for your companies, it is giving equal status to your partners in case of LLP, even in your companies, any changes in directors, any uh, a name change or your directors change or place of the address of your directors change, residential address of the directors change, all that needs to be informed to your ROC. See, the law is so exhaustive or giving you so many restrictions because they want to ultimately save the interest of the public, right? So that's why it is so there are detailed rules on what all you need to do in case there is any change. Okay, so that has to be intimated. If you look at this MCA services again, if you look at that mm, services in the form section, you have so many forms: LLP e-filing, form 3 incorporate information on LLP agreement, form 4 notice for change in information of partners, form 5 notice for change in name, form 8 is your statement of accounts, annual returns, intimating other address for service of documents. All so many forms are there. See, and you know what? The fines and penalties if you don't submit these forms within the stipulated time is like so high that every company or LLP they will not want to miss these deadlines. Even for companies, it's so high. It can go up to 5 lakhs and all in certain cases. So it's like it is important that ROC is informed of all the changes. Okay, so those are forms which you saw in MCA itself. So these are changes which need to be intimated to your ROC. Okay, a notice filed with the register shall be in such form, shall be signed by the designated partner. So all these ROC, IT, all those have to be performed by your designated partners. Okay. If it relates to an incoming partner, shall contain a statement that he consents to become a partner. All that, all procedural. You read it once, you'll understand. If the LLP contravenes any of the provisions, LLP and every designated partner. You see, LLP and every designated partner. So, designated partner, before he takes up that role, it is so important that he knows all these rules because he is personally liable. Every designated partner of the LLP shall be punishable with fine, which shall not be less than 2,000, but which may extend to 25,000. And any partner contravenes the provision, he will be punishable with the fine again. Any of the partners, then any person who ceases to be a partner of, see, this is that section, it is given over here, so it is actually uh, relevant for that. If any person ceases to be a partner of LLP, he may himself file with the registrar the notice if he has reasonable cause to believe that the LLP may not file the notice. So that's what we saw, right? Your it is the responsibility of the LLP to actually file with the ROC that this person is no longer a partner. But till ROC is informed, this person A continues to be the partner. So it is, the acts of the firm is binding on A also because he is also a partner, right? So if he wants to, voluntarily remove that status of being the partner because he is no longer the partner, he doesn't desire to be involved in this particular partnership, LLP, then what does he have to do? He can directly go and inform ROC. Usually it has to be done by LLP. But if he believes that this LLP is so negligent or this designated partner, he doesn't do anything on time. So what can he do? He can actually go and file with the registrar directly if he has reasonable cause to believe that the LLP may not file the notice with the registrar. And in case of such notice filed by a partner, the registrar shall obtain a confirmation to the effect from LLP. So he's going to cross check with the LLP on whatever he's saying is right or not. However, where no confirmation is given within 15 days, if within 15 days the LLP doesn't get any feedback from the partners from LLP, then the registrar shall register the notice made by a person seeking to be a partner under this section. So, what is the registrar going to do? He is going to tell, okay, I'm going to believe whatever is told by this person, this retiring partner A, and I'm going to remove his name as a partner from this LLP. So that is what he can do. Okay, so that is about your admission or somebody moving out of your LLP. Next, extent and limitation. It's all, I think, very, very straightforward, simple chapter. So we'll see how much we can complete. Extent and limitation of liability of LLP and partner. Now we saw between partners what is a relationship. Now extent of liability, LLP and partner. So every partner, this agency relationship is definitely there in LLP also, but it is not binding on all the other partners like your partnership firm. Here it is binding on the LLP for acts within done with the authority of the partner. Okay, so every partner of LLP is for the purpose of business of the LLP, the agent of the LLP. So he binds the LLP definitely, but not the other partners, but not of other partners. So that's what is your partner as agent over here. Section 26 talks about that. So he binds the LLP definitely, but not the other partners. Okay. And then extent of liability of LLP. So a person does any act, any partner can do anything, any act. So how much is the LLP liable? Extent of liability of this LLP for the acts done by partners. LLP is not bound by anything done by a partner in dealing with a person if the partner in fact has no authority to act, which means that the authority has to be given by the agreement, or it has to be your implied authority, anything done for the normal course of business, all that is implied, but it is not binding if the partner in fact has no authority to act for the LLP in doing a particular act. For example, beyond your ordinary course of business, we saw all that, right? Your teaching firm, suddenly I'm telling that, I will sell this projector to you. So that is not within the ordinary course of business. So LLP is not bound by that. The partner, in fact, has no authority to act for the LLP in doing a particular act, and the person knows that he has no authority, or doesn't know, or believe him to be a partner of the LLP. So it has to be, it is, and both these conditions have to be satisfied. If a third person believing he has done something within the ordinary course of business and acts accordingly, then it definitely binds the LLP also. But if it is beyond the authority, and the third person, has reasonable, uh, uh, reasonable, ways to believe that this person cannot do this act, then this LLP is not liable. So the partner has no authority to act for the LLP in a particular act, and the person knows that he has no authority, or doesn't know or believe him to be a partner of the LLP. In such cases, the LLP is not liable or not bound by the act of the partner. So when is LLP liable? The LLP is liable if a partner of LLP is liable to any person as a result of wrongful act or omission on his part in the course of the business with its authority. So of the business or with its authority. Okay. So if it's ordinary course of business or with its authority, if anything is done by any partner, then LLP is binding on the partner. An obligation of the LLP, whether arising in contract, shall be the obligation of the LLP alone. So it is not the obligation of the partners. The liabilities of the LLP shall be met out of the property of the LLP. So it is the personal liability of the LLP. So it is out of the personal property of the LLP. Okay. So next is your extent of liability of partner. Section 28 talks about that. A partner is not personally liable directly or indirectly for any obligation, okay, by reason of being a partner of the LLP. For all the acts of other partners, the any partner is not directly liable. It is only the LLP which is liable for the acts of the other partners. Okay. And provisions, okay, shall not affect the personal liability of a partner for his own wrongful act or omission, but a partner shall not be personally liable for the act of any other partner. So what are they trying to say? They're trying to say that, in case you personally or willfully fraud, so if you involved in such acts, then you will be personally liable. Your personal liability or unlimited liability in a LLP arises only in case where you have committed any fraud, or any act of omission which has resulted in liability to the LLP. So in that case you will be personally liable. In all other cases, it will not be liable, and the act or willful act or fraud of other partners, this particular partner is not liable. No partner is liable for the acts, willful acts, or your omission done by other partners. It is only the LLP or that particular partner, depending on the cases. Okay. So definitely in no case Other partners are liable for an act done by any other partner due to his, even in case of fraud or negligence, other partners are not liable. Okay, so that is the main point of differentiation between your LLP and your partnership firm. No, other partners are not at all liable in this case. Not at all liable as in your personal liability, personal property will not even come into picture. It is the liability of the LLP. Okay, so that is your liabilities. Next is your holding out. Holding out, have you heard of this partner by holding out? Do you remember that? Partner
Yes,
by
ma'am.
holding out, or what is the other word?
Partner
Partner
based open.
by estoppel, correct. So it is same thing. Partner by holding out. Any person who, by his conduct or words spoken or written, represents himself or permits himself to be a partner in LLP is liable to any person who has, on the faith of such representation, given a credit to the LLP, whether the person representing himself or represented to be a partner doesn't know that the representation has reached the person, so giving the credit. Which means that once you know act as a partner, then you are the partner and you are liable to other persons who in basis such belief they have acted on with you. So you are liable and you are equivalent to a partner in the firm even though you are not a partner, because it is very same as your partner by estoppel. You have acted that way, so you cannot stop later on from being a partner of the firm. Where any credit is received by LLP as a result of such representation, the LLP shall, without prejudice to the liability of the person so represented, the extent of credit received by it or any financial benefit derived thereon. Similar to your quasi contract. So, in case basis that representation, the LLP has received something, some benefit out of it, then you have to restore it back. Okay. So that is you, or you will be liable to the extent of credit received by it or any financial benefit derived thereon. So you have received benefit. In that case, what will happen? You are liable to pay, give that credit to that extent of the credit. Okay, so that is your partner by holding out. Partner by estoppel or partner by holding out, same thing. Next is your where after a partner's death. So very important. Where after a partner's death, the business is continued in the same LLP name. The continued use of the name of the deceased partners of uh, as a part thereof shall not itself make us legal representative or estate liable. Okay, so the day your partner, one of the partners, on the death of a specific partner, after that date, your legal representatives or your his estate will not be liable. Okay, because he will not be able to give the notice also, and LLP also, if they have not getting the final benefits right from the LLP, they are no way liable for any act which is done after the death of this particular partner. So it is the responsibility of the LLP alone with the remaining partners. So this particular partner is not liable. Or partner, sorry, this partner's estate is not liable. Representative or his estate is not liable. Okay, so because very simple, retiring partner, he has an option. If he knows that this LLP is not going to inform, he has an option to directly go to the ROC and inform, intimate that I'm not the partner anymore. But this person is dead, right? So nobody can blame this particular partner, and his whatever is his share of contribution and whatever he has to get from LLP, it is intact on that day that he will receive. He cannot be held liable for anything more than that. Okay, so uh, that is your whenever a partner is dead, what happens in case the LLP continues. Okay, so we saw that limited liability. We already touched upon this. We know that LLP always it always has limited liability for the partners. So when does this unlimited liability comes? In case of fraud, Section 30 talks about that. In case of fraud, in the event of any act carried out by LLP or any of its partners, carried out by LLP or any of its partners with intent to defraud the creditors of the LLP or any other person for fraudulent purposes, the liability of the LLP and partners who acted with intent to defraud creditors for any fraudulent purpose. So shall be unlimited for all or any of the debts of other liabilities of the LLP. Yeah. Okay, so you get that. So in case there is any fraudulent act done by LLP or any of its partners, and then the partner who's acted this way with an intent to defraud creditors, then his liability is going to become unlimited for all or any of the debts or other liabilities of the LLP. Okay, the act is carried out by a partner. The LLP is liable to the same extent as the partner unless it is established by the LLP that such act was without the knowledge or authority of the LLP. So here, what are they saying? In case that particular partner alone has done that, then it will be that particular partner. Okay, the fraud, it will be the unlimited liability of the partner. So LLP is also liable. LLP is liable to the same extent as the partner when unless it is established by the LLP that such act was without the knowledge or authority of the LLP. So basically, in crux, what are they trying to say? In case any fraudulent act is done by any one of the partners, then it will be obviously the act of the partner's liability, unlimited. Here, the personal or unlimited liability of the partners will come. Okay, so then there it will not be the liability of the LLP. But again, for doing that, for proving that, what is required? It is required by the LLP that such act was without the knowledge or authority of the LLP. So it has to be proved that it was without the knowledge or authority of the LLP. So if it is not proved, then even the LLP will be bound by such act. Okay, so unlimited liability of the LLP also is going to arise. Clear? So in case of fraud alone, and for the partners, only one and only in the case of fraud, your unlimited liability of the partners comes into existence. Again, here, what is the uh, twist over here? The other partners will not be liable. It is only the partner who has done this fraudulent activity, and he can also bind the LLP if LLP was also aware of this fraudulent activity. If LLP was not aware, then it means that it is the partner's liability alone. So LLP is aware as in the designated partners or the other partners. If they are also aware of this act, then it will also bind the LLP. Otherwise, it is that particular partner's liability alone. Okay. So that is about your fraud, and where any business is carried on with such intent or for such purpose as mentioned in subsection 1, as in this fraudulent activity, every person who was knowingly a part to the carrying on of the business in the manner aforesaid, the fraudulent activity, shall be punishable with imprisonment for a term. So what is, you know that this is wrong. So over and above your liability and all, what is also given by law is you are also punishable with imprisonment for a term which may be extending up to 2 years, and with a fine which shall not be, which will be between 50,000 to 5 lakhs. So that is the punishment which is given for fraud, and liability of that fraudulent activity, it will be on the partner who's done the fraudulent activity, but not binding the other partners, but it will bind the LLP when LLP was aware of that fraud. Okay, so that is what your fraudulent activities talks about. And where LLP or any partner or employee has conducted the affairs in a fraudulent manner, then the LLP and any such partner or designated partner shall be liable to pay compensation to any person who has suffered any loss or damage by reason of such conduct. However, such LLP shall not be liable if any such partner has acted without the knowledge of the LLP. So, acted fraudulently, but without the knowledge of the LLP. So, in that case, LLP is not liable. LLP is not liable as in any penalty losses. It will not come into his books. So, it is any fine. It will be the partner's individual liability. The partner has to bear that if he has done that act, if he has done that act without the knowledge of the LLP, and that act was an act of fraud. Okay, so that is all about your fraudulent activities. Next is your whistleblowing. Whistleblowing is, I think, the second last topic. Next is your, a few more topics, but whistleblowing is again an important topic over here. Whistleblowing. Have you heard of this term whistleblowing anytime? Whistleblowing. Not just for LLP, it's a very popular whistleblower. Have you heard of it anytime? Whistleblower.
No.
Yes, ma'am.
So who's a whistleblower?
Ma'am, I think the inside employees say some things about the company,
Very good. Correct.
confidential details.
Correct. Correct. Not confidential matters. So, being part of that organization, you know that something is not being done correctly, or some act of fraud is happening, or they're trying to hide something from law. All that because you're part of that organization, insider, you are aware that there is something wrong which is happening inside that organization. So what do? Suddenly you want to become the approver, or you need not be a part of that crime. You know that that act is not right, which is being done inside your organization. Excuse me. So what can you do? You can actually go and tell media, or your ROC, or any or your police station, or even media is so popular these days, right? You just like that, call media and then inform them that this is not being, that this is what is happening in that particular company. So if that is being done, then that is called whistleblowing. Okay, it's a popular term, not just in LLP, but generally it is a popular term, whistleblowing. So in case of LLP, what happens? The court or tribunal may reduce or waive any penalty leviable against any partner or employee of a LLP if it is satisfied that such employee or partner has provided useful information. So maybe he was also part of a crime. This partner was also part of the crime till yesterday, but today he becomes a saint, and suddenly he wants to tell the world that this is something which is happening, this wrongful act is being done in the company. So if you come forward and do that, then you can waive any penalty. So if something was punishable, that was your payment which you need to make, the penalty which you need to make, then government can actually come forward and reduce that penalty. It's same as your approver. You would have seen in a number of movies, right? Suddenly you realize you want to reduce your jail term or something, you can go and become the approver. You voluntarily go and inform that something wrong has happened. You may be part of it, or you may not be part of it. And you may, if you are part of it, and if you come forward and inform now, then what is going to happen? They could reduce or waive your penalty. Or when information given by any partner or employee leads to LLP or any other employee being convicted, okay, so he can even for conviction, he can be waived, or he can be the penalty can be reduced. And no partner or employee of any LLP may be discharged, demoted, suspended, threatened, harassed, or in any other manner discriminated against the terms and conditions of his LLP. So because this person came forward and informed your authorities about some wrongful act, the law protects you from saying, you cannot be discharged, demoted tomorrow. If you're not being given your promotion, or you're being demoted or suspended, all that is happening, then you can, or then you're obviously protected. Law protects you from all those. Okay, so basically what will happen, law will say that they will protect, but end of the day, you are the person who are going to suffer, right? So you have to come out of that organization once you blow the whistle. That is the practical scenario. But yeah, law says that they protect you from all these harassment or threatens or your suspension. All that law protects you in case of people who whistleblow. Okay, so that is about whistleblowing. You could just get 3 or 4 marks questions on what is whistleblowing in LLP. Small topic. Okay, next is because they have to ask something from LLP, and they could come up with altogether new thing and start asking you 3 marks on whistleblowing and 3 marks on some practical question. Number of members, they could give that, two non-residents are designated partners. One person was a foreigner, and then one person is away from India for 190 days in the last year. So in that case, what is the, is it valid? So you'll have to just give your opinion or conclusion on whether it is valid or not. So possible questions. Okay, next, moving on to financial disclosures. I told you, right, that though you don't have to, the extent of your returns and filings are not so much like your companies. Even your LLP has financial disclosures. They have to maintain books, not like a partnership. It is not, it is not mandatory, right? So it is up to the partners, the firms, unless you're registered. Now in case of your LLP, it is mandatory. It ROC says, that law says that you have to file these documents with the ROC within stipulated time. So what are those documents? Maintenance of books of accounts, other records and audit. That's all given in your section 34. Proper books of account. They shall maintain proper books of accounts. You have to have books of accounts and all relating to its affairs, cash or accrual basis, double entry system, and you have to maintain those documents in your registered office. Now it's all in electronic mode, so it's all fine. But yeah, still you have to have it in your registered office for such period as may be prescribed. And statement of account and solvency. Every LLP shall, within a period of 6 months from the end of each financial year. So within a period of 6 months from the end of each financial year. So your financial year ends on 31st of March, right? So which means that within 30th of September, within a period of 6 months from the end of each financial year, prepare a statement of account and solvency. You saw that in your LLP, right? That form was there. E-filing, where is it? Services, MCA services, LLP e-filing, annual return, statement of accounts and solvency, form 8. So that form, in that particular format, you are allowed to give your statement of accounts and solvency within a period of 6 months from the end of each financial year. Prepare a statement of accounts and solvency for the said financial year in that form, such form, that form which we just now saw, form 8. Such statement shall be signed by the designated partners of the LLP. So whatever these compliance related issues, it's all falling on the head of your designated partners. That's why you have designated partners. They have to do this. Okay. Every LLP, you'll see if they don't do that, what is the punishment? Every LLP shall file within the prescribed time the statement of account and solvency prepared with the registrar. Okay. Every year, the accounts of LLP shall be audited in accordance with such rules as may be prescribed. However, the central government, so what does the central government do? Central government, they say that if your turnover doesn't, they might keep changing that. If your turnover doesn't exceed so and so limits, then your accounts need not be audited. But it's not like companies accounts have to be audited, okay, irrespective of whether your company makes losses or profits. So that is not the case of LLP. That's why I told you, there are restrictions, but restrictions are relatively simpler in case of LLP. Okay, now your, so what if you don't file a LLP which fails to comply with the provisions of this section shall be punishable with the fine which shall not be less than 25,000, which may extend up to 5 lakhs. And every designated partner, very important, every designated partner, he was responsible for doing this, right? So every designated partner shall be punishable with a fine of 10,000 to 1 lakh as the case may be. Okay, so those are the punishments. Those are the fines which needs to be paid by your designated partners in case he doesn't do that. So obviously he will be interested in filing it on time. And annual return, section 35 talks about your annual return. Every LLP shall file annual return duly authenticated by the registrar. So what is annual return? Again, your books, annual accounts, and your books of accounts, annual accounts, that is different. Your financial disclosures are different. Your annual report will have your annual return is like your annual report. Like you would have seen companies' annual report. So it's all freely available. If you just Google and see annual report of so and so companies, you can just get a PDF of that. So it will give you everything of what happened in the company during that one full year. The contracts which they entered into, the major businesses which they carried on, what was profitable, macroeconomic environment, what new products they launched. All that will be part of your annual report. If you get a chance, just read that director's statement. Directors will tell you, they talk to the people and they tell what happened in the company during that year. And not just your numbers. You see, get the profit and loss account, balance sheet. It is giving you the financial disclosure of all that which has happened during the year, But what was the driving energy? What happened in the company? That and all you'll not get in your profit and loss account in your balance sheet. That's why you have annual report, annual return. So that will give you the detailed transactions and businesses and macroeconomic environment, how the company performed compared to the peers. So many things, your corporate social responsibility, all that will be part of your annual report. So that also needs to be filed with the registrar, and that's also applicable for your LLP annual return authenticated with the registrar within 60 days of closure of its financial year. So if you look at uh, the accounts, then that is 6 months from the end of financial year, right? So 6 months, as in from 31st of March, it is 6 months from the end of financial year, 30th of September. But here it is 60 days of closure of its financial year. 60 days of its closure, as in 31st of March is your closure of financial year. So which means that April 30 days and May 30 days. So it is 30th of May. It doesn't tell you 2 months. So which means that whatever the law tells you, I don't know why lawmakers are too confused so much, saying that here there in the previous section it is 6 months from the end of financial year. Here it is 60 days from the closure of financial year, which people might always assume that it is 31st of May, isn't it? But it is not 31st of May. It is 30th of May because it specifically says 60 days. So it is April 30 days and May 30 days. So 60 days. 30th of May, you have to file your annual return. Okay, so the financial year closes on 31st of March. That's why they've given you an example also, so that you are uh, um you're looking at this particular difference alertly. So this is 60 days. So it is 30th of May. The LLP contra has prescribed the filing of annual return in accordance with the Companies Act 2013. This is a new feature of the LLPs. Okay, next is any LLP which fails to comply with the provisions. In case you are not complying with the provisions, then your fine will be 25,000 up to 5 lakhs. If LLP contravenes the provisions, the designated partner, again, if the annual report is not filed, then it is 10,000 to 1 lakh. So the designated partner has to ensure that he is filing the annual return. So that's things, right? That's form 11, I think. 11 statement of account and solvency and annual return 11 that has to be filed. Uh, okay, so that again is conversion into LLP. Into LLP, so that is possible. A firm may convert into LLP in accordance with the provisions of this chapter and the second schedule. So it is not given in detail with what is there in that. There are schedules given the LLP Act. If you're interested, you can just Google it and see. So you have first schedule, second schedule, which talks about various headings. So conversion is given in your second schedule, and conversion from private company into LLP. A private company may convert into LLP in accordance with the provisions of this chapter and the third schedule. Okay, conversion from unlisted company into LLP. Firm is given over here, and then private company is over here. An unlisted public company may convert into LLP in accordance with the provisions of this chapter. Okay, so if there's an unlisted public company which wants to convert into LLP, that is also possible. You have to follow just the steps which are given. Registration and effect of conversion. Once converted, what is the effect? And either ways, this way is also possible. LLP also can be converted into private company. That is also possible. The registrar, on satisfying that a firm, private company, or an unlisted public company has complied with the provisions, register the documents, issue a certificate of registration as the registrar may determine, stating that the LLP is on and from the specific date of date in the certificate registered under this particular act. So he can say that LLP. This from this day onwards, this particular organization is becoming an LLP. And LLP shall, within 15 days of the date of registration, inform the concerned registrar of firms. So obviously earlier you were register, you were a partnership firm, so you were under registrar of firms. Now you are a registrar of companies, so so you'll have to inform within 15 days of the registration, inform the changes to the specific to the particular registrar, ROF or ROC, as the case may be, about the conversion. Okay, so that you will do. Again, what is the form for that? You can see over here. Notice of an application of direction. Okay, sorry. Mhm. Notice of intimation of order application LLP to change its name, application for striking its name. Okay, no, only foreign companies and all that is given. Maybe that's not part of this. So you'll have to just give it in the specific form, whatever form is there, to the registrar or register of firms, that this is becoming an LLP. Okay, next. Okay, to which partners and the partners. So basically, once you become that particular LLP, then all the acts of this particular LLP act will prevail for your organization and not your company going forward. Upon such conversion, on from the date of certificate of registration, the effects of the conversion shall be as specified. Okay, so and effect of registration, what will happen? There shall be a LLP by the name specified in the certificate of registration under this act. So that company or partnership firm, they're going to become LLP. All tangible and intangible property vested in the firm or the company, as the case may be, all assets, interests, all that of the firm, uh, as the case may be, shall be transferred to and shall vest in the limited liability partnership. Okay, and the firm or the company shall be deemed to be dissolved and removed from the records of the registrar of firms or the companies, as the case may be. So what do they say? So once you fill this form, once you become this particular LLP, then the erstwhile organization becomes dissolved on its own. Automatically, it comes to a dissolution. Okay, so that is about conversion. There are just a couple of more topics. We'll try to finish it off. Okay, yeah, just two more pages. We'll just see if we get next lecture. What do you have? You have anything now?
Ma'am, we don't have anything. This is the last session.
Okay, then we'll continue. Then we'll continue for 5 or 10 more minutes. Next is your foreign LLP. So I want to finish off this. Next, we'll have law related. Okay, we'll first of all finish off this one, and then we'll start discussing. Foreign LLP, what is a foreign limited liability partnership? So rules for provisions in relation to establishment of place, similar to your foreign company, is relation to establishment of place of business by foreign LLP within India and carrying on their business therein by applying or incorporating the provisions of the Companies Act, such regulatory mechanism with its composition as may be prescribed. So very similar to your foreign company, you can also have a foreign limited liability partnership. Foreign companies who have place of business in India, they can have this foreign LLPs. That is possible. Section 59 talks about that. And you also know that a foreign LLP can also be a member in your LLP, can be a partner in your LLP. That is also possible. So body corporate, you saw that this also is there. So your foreign LLP can also be a partner in an Indian LLP. That is also possible. Okay, next is your winding up and dissolution. So similar to your partnership winding up, voluntary dissolution, and then court, you also have dissolution of a LLP. What happens? Winding up LLP may either be voluntary or by the tribunal. So what? When does an LLP may be wound up? LLP may be wound up by the tribunal. So when is the tribunal going to wind it up? If the LLP decides that LLP be wound up by the tribunal. So it can also be like, the partners are deciding, the LLP is deciding that the LLP will be wound up with the intervention of the tribunal. So that case, or if for a period of more than 6 months, the number of partners is reduced below two. You remember this? There has to be at least two partners in every LLP. So in case there are less than two partners at any point in time after 6 months, then this partner is going to be personally liable. That is also applicable, right? We saw that, right? So that person will be uh, liable personally. The single partner who's carrying on, he'll be personally liable. And it is also possible that, the tribunal says that this particular LLP has to be wound up altogether. Because, why are they giving that section, that clause and this clause both? They're saying that there is unlimited liability, right? Obviously, when the court is going to, when the tribunal is going to dissolve your LLP, it is not going to happen on day one. It will take some time, right? So in the meantime, if that partner is entering into any contracts, that will be the personal liability of the partners. And over and above that, the LLP itself will be dissolved if for more than 6 months the number of partners is reduced below two. The tribunal has the right to dissolve that LLP. If the LLP is unable to pay its debts, if the LLP has acted against the interest of the sovereignty and integrity of India, the security of the state or public order, these are all common sense points. No organization can actually, not just LLP, no organization can prevail in India if it's doing something which is against the interest or security of India. So next is here, if LLP has made a default in filing with the registrar, the statement of account and solvency or annual return, your statement of account and your Form 8 or Form 11 for any 5 consecutive financial years. Okay, so it has to be 5 consecutive, as in 5 continuous financial years. So now it is 2022. So 2022 you're not filing, 2023 you're not filing, 2024 you're not filing, 3 years you're not filing, and then suddenly 2025 you're filing, which means that 5 consecutive financial years, that is broken. So in that case, your tribunal cannot wound it up. It has to be 5 continuous financial years. Okay, if for 5 continuous financial years your designated partner has not filed the statement of account or your annual return, then this LLP can be wound up. Okay, and if the tribunal is of the opinion that it is just and equitable for the LLP to be wound up, any other case, it is like etc. Any other case, the tribunal thinks that the LLP should be wound up, then it can be wound up. Rules for winding up and resolution, the central government directs you or guides you in relation to how the LLP should be wound up. Okay, so that all is not part of your syllabus in detail. The LLP itself is a new form of organization, right? 2008-9 only, and there are not that many companies which are in the form of LLP, because it's like altogether a new thing. People are still familiarizing themselves with the concept. What are the advantages and disadvantages of LLP form of business? So uh, this is what is there in your syllabus. So this much is enough. And then other things, business transactions of partner with LLP. A partner, obviously, it's like your company only. Your partner may lend money to and transact other business with the LLP, because LLP is a separate legal entity, right? Like your company. So partner can have transactions with your LLP. So that is possible. Application of the provisions of the Companies Act. The central government direct that any provisions of the Companies Act specified in the notification shall apply to LLP or shall apply to LLP with such exception, modification, adaptation. So central government has the authority to give or guide you on what is applicable to LLP from the Companies Act. But Partnership Act is not applicable for LLP, right? Your Indian Partnership Act 1932 is not applicable for LLP. Okay, unless it is specifically mentioned. But your Companies Act, many times it is applicable. Companies Act, you take extract here and there the section, the part of your Companies Act in your LLP. And a copy of every notification proposed to be issued shall be laid in draft before each House of Parliament. So how is it being the notifications are being done by the central government shall be laid in the House of Parliament while it is in session for a total period of 30 days, which may be comprised in one session or in two or more successive sessions, and before the expiry of the session, immediately following the session of the these are all structural or operational, or how the notifications have to be given. before the expiry of the session immediately, all that. Okay, both houses agree in disapproving the issue of the notification, or both houses agree in making any modification in the notification. The notification shall not be issued, or as the case may be, shall be issued only in such modified form as may be agreed by both the houses. Okay, so those are all procedural things. Electronic filing of documents. So nothing is, everything is electronic. E-filing, they call it as. Everything is e-filing only. Companies or your LLPs. Any document required to be filed, recorded, or registered under this act may be filed, recorded, or registered as may be in such manner and subject to conditions as may be prescribed. Prescribed as in whatever the ROC says. They give you specified forms for specified things, so you will go based on that. And all that is available with the registrar of companies. They're all public documents. Once you file it with the registrar on payment of fee, anybody can extract it, so it becomes a public document through a fixed digital true extract from any document filed with or submitted to the registrar. Okay, so it can be given as evidence. So these documents, once you submit it to the registrar, then it becomes a document for evidence. It becomes a public document. It can be given for evidence also. Payment of additional fee. Any document or return required to be filed is not filed or registered in time. We saw that there has to be additional fee or penalty which will be payable by the LLP or the designated partner as the case, and the designated partner as the case may be, up to a period of 300 days from the date within which it should have been filed, on payment of additional fee of 100 for every day of such delay, in addition to any fee as is payable. So in case you don't make payment, you don't make filing of any documents which need to be registered or filed with the registrar, then 100 rupees for each of the day up to 300 days they are giving. Okay, however, such document may also be filed after such period of 300 days on payment of fee and additional fees specified in this section. So all operational, how you will file documents, what will happen if you don't file the documents, what will be the fine and all. You just have to be aware of what is there in these things. Okay, then last is your differences with other forms of organization. We just saw in the beginning itself. So that ends your LLP, limited liability partnership. Pretty straightforward. Yeah, please go through this well. It is not voluminous also. It is not voluminous also. That is the biggest advantage of this. The syllabus which is given to you, it is not voluminous also, and it is very, very straightforward. So 6 to 8 marks surely you're getting from this. Okay, have mindset that way. Okay, so that ends all your acts applicable for you. That ends your law as well. So from next session onwards, we'll be looking at your BCR, okay, correspondence and writing. That we'll start with. Now, before we start with that, tomorrow, I think tomorrow we'll have a session. Tomorrow, what we will do is, for law, how do you have to, what are the tips, major tips for examination? I'll start with that. We'll probably take,
Ma'am,
yes,
ma'am,
yes,
is the topic of basic characteristics completed in this LLP? Those
Okay,
16
that is
points.
not covered. Okay, yeah. Let's do that now itself then. Okay, same thing. What we will just quickly go through that. Okay, we'll do that. So tomorrow, what we will do is, before we start with BCR, we'll or tomorrow itself we'll see this also. It's 12:10 already. So what we'll do is we'll quickly have 5-10 minutes for this. This is like, just jotting down all the points whatever we discussed. So we'll quickly have a look at it, and then see examination tips from law's perspective. Okay, from law, whatever are most important tips from examination perspective, and the weightage of marks given to each chapter, that and all we'll see. We'll quickly take half an hour for completing all this, and then we'll move on to BCR. Okay,
Yes, ma'am.
so we'll stop for the day here. Thank you, students. Any doubts, any questions? And this weekend we are having a test on Contract Act plus your partnership. Okay, Contract Act, I'm not limiting to your sections which were left out. So you will revise the entire Contract Act. But I'm telling you now, I'm telling you, giving it to you. I'm telling you that the main test is going to be on partnership firm and Contract Act. I might ask a couple of questions. It might be from the chapters which are left out, or it could be something which I asked previously also. Okay, so I want you to basically revise the entire Contract Act. and partnership firm. Okay, that will be the test for this weekend. Okay, students, that's it for the day. I'll stop sharing. Thank you so much. Thank you for your time.
Thank you,
Bye.
ma'am.
Thank you. Bye.
Thank you, ma'am.
Thank you, ma'am. Thank you, ma'am.